Hello and welcome again to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group, and we have offices located in Ridgewood, New Jersey. We also have an office in Midtown Manhattan. We have offices located also in outside of Boston and in Chicago, and for the convenience of our clients. And we also have an office located in Indianapolis, Indiana. And today what I'd like to do is spend a little time discussing the I-9 form. And one of the things that we've noticed is that there's been a tremendous uptick in I-9 investigations. We, of course, have always, and I believe in other videos, have mentioned the importance of doing I-9 audits internally to ensure that your I-9 forms are done properly. Just to give you an idea, of course, there's several violations with regard to the Immigration Reform and Control Act, which was implemented in the law back in 1986. And the Immigration Reform and Control Act basically was the law that created the I-9 form. In that law, it made it illegal to knowingly hire or retain an unauthorized worker. It also of course, provided for what are called paperwork violations in the event that an I-9 form has not been properly filled out, or has not been properly filled out, at least with regard to the procedural protocol. Because there is something called a paperwork violation, but there's also a form of discrimination that takes place if an individual is not allowed to show the types of documents they want to show. So if an employer tells an employee to show more or different documents than those that are listed on the list A, B, and C on the I-9 form, then an employer could potentially be charged with a form of discrimination. It's called document abuse. So what we're noticing as we're working with our clients and with other organizations that are asking us to provide training and I-9 and employment verification support is that, number one, a lot of the I-9s are not properly filled out. So it's very important to make sure that all the I-9s are properly filled out. If you go back and you do an internal audit, please remember that Section 1 can only be changed by the individual, the employee. Section 2 can only be changed by the employer. And it's very important that if the employee makes changes to Section 1, that they initial the changes that they're making and that they also date those changes. And the individual who's making those changes with them to Section 1 or overseeing them also ensure that if they're making changes to Section 2, that they initial and date those changes. And of course, there's no substitute for the possibility of putting together a memorandum to the file which explains why the changes were made to the form, and also, of course, notating that it's in connection with an internal audit that's being done by the organization. So those are some of the things that are very important to doing an I-9 audit. We emphasize that to our clients that if they have not done an internal audit, it's probably a good idea to go ahead and do it as a prophylactic in the event of an I-9 investigation. Now, an I-9 investigation is usually started by the Immigration and Customs officer coming to the place of business and giving the employer what's called a notice of inspection. And within 3 business days, the employer is required to hand over their I-9s and any documentation supporting those I-9s. There's also a list of other documents that the employer needs to give. Usually it's payroll records and also other types of tax documents. And those documents also have to be given to the Immigration and Customs Enforcement officer. Once they've had those documents for a while, the Immigration and Customs Enforcement Office will then submit back to the employer, if necessary, what's called an NSD, or a Notice of Suspect Documents. And usually several employees may be listed on that Notice of Suspect Documents, and then appropriate steps need to be taken with regard to those particular employees. Later, there's another document that's submitted. It's called Notice of Technical and Non-Technical Violations, and then an employer has an opportunity to possibly cure those technical or non-technical violations. Ultimately, if there are violations that are found, an employer will be given what's called a notice of intent to fine. After the notice of intent to fine is issued, then an employer has 30 days in which to ask for a hearing. So they have to make sure that they ask for that hearing within 30 days of receiving the notice of intent to fine. We assist many employers with regard to internal audits. We also assist employers with regard to preparing I-9 forms, preparing I-9 training programs. We'd be happy to assist you if you have any questions. Probably the best place to start, which we tell all of our clients or potential clients who are thinking about doing internal audits, or even those that we're preparing internal audits for, is to take a look at the M274. It's a document that you can locate on the USCIS website, located at www.uscis.gov. And there you'll find a form M274, which is an excellent training guide or training manual that all of your human resources staff should take a look at, which explains step by step how to do the I-9 process. Thanks very much for being with me today. Please take a look at some of our other I-9 videos. Also, I just want to let everyone know that the I-9 form is due to be updated very soon. The comments, today I believe is the last day that the comments were due, so we're going to be hearing something very soon from the USCIS with regard to the new I-9 form. There probably will be additional videos on this subject matter forthcoming. Thanks very much for being with me today. Bye for now.